May be seated. All right. Okay. Call the case of Rodgers versus Rausin. When you're ready to proceed, would you like to reserve any time for rebuttal?
Yes, Your Honor. I'd like to reserve 4 minutes for rebuttal.
Okay. The light will turn yellow when you're at 4 minutes, and I'll try to remind you as well. And let me just remind everybody, I'm doing this for myself as much as anything, that we did it in an order that's going to preserve the confidentiality of the settlement amount from the previous General Motors case. So we won't be mentioning it, and you won't be mentioning it either. So, okay, very good.
Correct.
You can proceed.
Your Honors, Angela Flowers on behalf of Defendant Susan Rodgers. I have with me at counsel table Michael Romano, who was trial counsel below. This case is before the court on primarily 3 issues on appeal. Each of them arise out of different procedural contexts for this case. The first issue is that involving the question of whether or not there was a pre-suit settlement which was effectuated in this case and should have been enforced by the trial judge. The validity of the pre-suit settlement came up on motions for summary judgment. Cross motions were filed and heard by the trial court judge. In essence, the trial judge ruled that there was not a timely performance of the settlement offer. And if I can just now back up and give a little background, I'd like to put this in context of how the judge got to that ruling. This case initially started out with counsel for Susan Rodgers contacting each of the claimants who was in the automobile that was struck in this case and offering to jointly bring them together and to pay her policy limits. Let me ask you this. It's
a little confusing to me. I'm not sure whether you're arguing that this was an offer for a unilateral contract or an offer that could be accepted by promise.
I'll clarify that. I apologize for any confusion. I saw it myself with some perhaps typographical phraseology. We recognize that this was an offer for a unilateral contract.
Okay.
Now, where the parties diverge is in discussing what type of unilateral contract this was. And it is defendant's position that this was a standard unilateral contract which was covered by general Florida contract law and the restatement second of contract, section 45.
To quote from your brief, for the acceptance of a settlement offer to result in a contract, it must be absolute and unconditional, identical to the terms of the offer, in the mode, place, and within the time stated in the offer. And I guess the issue here is whether the acceptance was in the time stated.
And more specifically, whether the declaration of coverage sheet was provided within the 15 days demanded by the unilateral offer to contract.
Primarily the focus is in that area, but if I could just clarify. The offer for settlement set forth 4 conditions. The conditions were that there would be payment of the policy limits, that the insured or...
And there's no question that that was done within the 15 days.
There's no question that that was done. That there would be a release exchange. There's no question that that was done.
Well, except that the release had indemnity.
And I'll get to whether or not
maybe we should just let you talk for a while.
Unfortunately, this one is everything's intertwined, and it can sometimes need to be unraveled a little bit. So back to the elements of the settlement offer. The offer was that the policy limits be paid, that a release be provided, and that Ms. Rodgers comply with Section 627.4137, the Insurance Disclosure Statute, and in addition have her insurer, State Farm, supply a declarations page to the policy, because State Farm had already complied with 627.4137, but had left out the deck page. So we had those 3 conditions that she's going to tack on her confirmation of policy coverage and the deck page, and that this be done within 15 days. It is defendant's primary position that there was complete performance, that all of these...
And that position is based on the argument that it was really 30 days, not 50, because the statute says 30 days.
It's based on 3 arguments, and I go through them falling back as one does not perhaps catch the court's attention. The first and primary position is that there was complete performance because when you look at the whole of the letters that had been exchanged, the money was sent, a release was sent, and as I'll get to later, a release that was in compliance with the terms of the offer, and that Ms. Rodgers had previously, in a prior letter that had been dated February the 2nd, provided information to the claimants that her insurance carrier was State Farm, that the limits were $25.50.
But I mean, that didn't say there are no other coverages that might apply.
It did not say there are no other coverages.
I'm having a hard time understanding how that met that condition.
Because plaintiff didn't ask for that. What plaintiff asked for was that Ms. Rodgers comply with 627.4137. Nowhere in 627.4137 does it ask for...
Didn't it ask for her to confirm the non-existence of other coverages?
Not in the February 12th letter, which is the settlement offer. It is not until after the tender of performance is rejected that plaintiff puts in a letter, oh, what I was asking for was that affidavit that you don't have any other coverage and you don't have any personal funds that would cover the loss. That comes up after the fact. That's a subjective, unknown desire of the plaintiff, which is not contained in the February 12th letter, which is the settlement offer letter. So, it's our primary position that everything that was asked for...
Now, it was my understanding, I'm reading from the letter, if I can get this coverage disclosure revealing no other coverage and a verified declaration sheet matching the policy forms along with settlement, that is the February 12th letter, right?
Yes, and read in context...
He asked for...
That has to be referring back to what he asked for, which was compliance with 627.4137. Yeah.
Okay, well,
Reading
it
this
says I want
objectively,
the disclosure revealing no other coverage.
to the extent
And
that
when
he
did
was...
she do that?
Well, that's the deck page, because he had not had the deck
It said
page.
and the deck sheet.
And a verified declaration sheet matching the policy forms.
To the extent that he is asking for this regarding the disclosure of coverage, the only element that was set forth before his summary sentence was a request that she comply with 627.4137. So I'm going to summarize my initial position so that I can move on to my next position. But reading this February 12th letter objectively as to what it requested, that it requested compliance with the statute, and that she technically had complied with the statute, we believe that all performance was completed within that 15 days when the package was delivered by Federal Express. All right. In any event, the letter likewise, in referring to and asking that there be disclosures under 627.4137, incorporated that statute into the settlement offer. By incorporating that statute into the settlement offer, there was going to be a 30-day time limit within which to comply with that part of the request, so long as the 15-day time limit got all the performance in that could be accomplished. So what we have...
That's how you read that paragraph? Well,
It's not how I read a particular paragraph of the letter, but that's how I incorporate the statute into the settlement offer.
You're not taking the position that the person proposing the unilateral contract couldn't change the terms of the time terms of that statute?
No, but case law which governs how time deadlines which are within a statute are treated when a statute's incorporated into a contract require that there usually be some explicit statement that they're going to change the time deadline that's applicable under the statute. So in this case, there was no specific reference to changing the time deadline that was
It says if I can get all this information within
the
15
next
days.
15 days.
That seems to be changing the time.
What's your third position?
Having said all
not buying that one.
Having said all that, if there was not complete performance, and if defendant did not have within 30 days to comply and get everything to the plaintiff, we look to the law of contracts to determine whether or not a settlement agreement was formed, whether or not there was a settlement contract. Because once a settlement contract is in place, plaintiff cannot then unilaterally revoke the contract. And I rely here upon Florida law, specifically Florida's adoption of the Restatement of Contracts, Section 45, which deals with unilateral contracts. And what Section 45 of the Restatement says is that where there is a unilateral contract that is just a straightforward...
It says once the performance starts, you can't withdraw the offer.
Right, we're talking about a
And
straightforward...
my question is, has that ever been applied to extend the time required? I mean, that's what you're trying to do. You're trying to say, well, within 15 days I started performance, so then I could finish whenever. The 15 days no longer matters. I really don't think that's the law, is it?
In essence, the Hansen versus Maxfield case applies this concept. And I'll walk through how, although they don't cite to the restatement second, you see its application. When you go and you look at all these settlement cases, and sometimes they're approved and sometimes they're not approved, in essence, every one of them that ends up approving a pre-suit settlement, when you march through and read those decisions, they are applying the concepts of the restatement second, Section 45. The cases that don't approve the settlement agreements are usually applying the law that exists and is recognized within Florida, that when you go beyond just a basic offer of a contract that's going to be accepted by performance, and you put special language into the offer, for instance, language which says this offer may only be accepted by complete performance.
Your position that an offer for a unilateral contract with a specific time for performance, that if you start performance, that it extends the time for performance beyond. You no longer have to meet that requirement of timely performing.
What you were saying is correct, because what you have to do within that 15 days is accept the offer by manifesting mutual assent to each of the material terms.
No, not mutual assent, because a promise can't support consideration for a unilateral contract.
Many of the cases blend in that language, but what in essence is you are acknowledging that you accept all of the terms and you're initiating performance. And the Hansen versus Maxfield case applies this concept. Because in Hansen versus Maxfield, it was a nearly identical letter. It was an offer for settlement that spelled out certain requirements, one of which was compliance with 627.4137. The Mansfield letter offering to settle also had a time limit demand in it. I had to attach the briefs in order to clarify that it was a 30-day time limit demand, which is discussed in the appellate briefs in that case. There was a time limit demand. The plaintiff in the Mansfield case sought to repudiate the offer on the grounds that it didn't think it received an adequate disclosure, a disclosure that complied with 627.4137. So just like in this case, in Mansfield, the party accepting the offer took the steps and did everything within the time limit demand, but have an agreement as to whether or not they had compliance with 627.4137. And that's the same situation we have here. And the reason Section 45 restatement contracts comes in is because what it says is that once you initiate performance of a unilateral contract, it becomes an option contract. And the offeror can no longer interfere with your ability to complete performance under the contract. When you get into disputes over whether or not there was adequate compliance with 627.4137, it becomes an enforcement issue, because we know the terms of the contract. The defendant has manifested, their performance by initiating performance and by recognizing all the material terms of the contract, so that we have a situation, it converts it to an option contract, and
so you can extend the 15 days as a result.
In essence, it will extend the 15 days only because the ability to complete performance is extended.
Let me ask you to do something. You're down to 7 minutes, and you reserve 4 for rebuttal. I'd like you to address the set-off issue, because I don't want you to run out of time before we have a chance to discuss that. Would you switch to that real quickly?
Yes, Your Honor. In regard to the set-off, it was first raised in this case as an affirmative defense, that the defendant would be entitled to a set-off from the jury's verdict.
I was going to say, we all agree that General Motors wouldn't be a Fabre defendant, correct?
Correct.
They couldn't have been on the verdict form.
And that was the discussion, and that's how it reached
the... And it's the same injury to the plaintiff, correct?
That is correct. It's the same injury.
Right. Everybody, that's undisputed between everybody, correct?
I won't speak for plaintiff's counsel, but I agree with Your Honor in terms of that summation. So catapulting off of that, we have a situation where, because of De Mario, that this was not a situation where GM could have been put on the verdict form. So it was handled.
They're not a joint tortfeasor.
Because De Mario says they're not a joint tortfeasor. They're not a joint tortfeasor for purposes of comparative negligence law and the statute. So it was set up to be handled as a set-off issue. So post-trial, it was brought before the trial judge. We believe that he erroneously applied concepts of comparative negligence. that although this was a statute that didn't apply, and because it didn't apply, the defendants were not able to put GM on the verdict form.
Would you say there's still several liability for non-economic damages? Is that correct?
He, in many ways, decided to split the baby and say that even though you weren't joint tortfeasors for purpose of getting to put them on the verdict form as Fabre, we're going to use a Wells methodology for set-off.
Right.
It's the defendant's position that if the comparative negligence statute doesn't apply, you don't get to use any part of it. Defendants didn't get to put them on the verdict form and pursue them as a Fabre defendant, so you don't get limited by the comparative negligence statute in terms of the amount of set-off that you get. You revert back to how set-offs are handled when that statute didn't exist and when that statute doesn't apply. And when that situation, you go to the set-off statutes, and the set-off statutes look to see whether or not you have the same injury or damages. If you have the same injury or damages, then you should receive 100% set-off.
Well, does DeMario discuss non-economic damages?
No. DeMario fails to anticipate any of these problems in regard to a plaintiff who sues both the manufacturer and the automobile accident tortfeasor. So it's not discussed in that regard, nor is there any discussion anticipating how set-offs would be employed. So again, it's our position.
In Wells, the court says the plaintiff's claim against one defendant for non-economic damages can never be the liability of another defendant. In other words, so when General Motors paid, they could never pay your client's obligation for non-economic damages. I mean, unless it was gratuitous.
If Section 768.81, the comparative negligence statute, applied, yes. Because of the complexity of this case, I'm going to make sure and reserve my full remaining time for rebuttal. Okay. Thank you.
Good morning. I'm Shea Moxon, and I represent the appellees. On the settlement issue, Ms. Flowers has conceded that this was an offer for a unilateral contract, so that makes it fairly simple. Everything had to be performed according to the offer's terms for there to be an acceptance and for a contract to be created. Her interpretation of Section 45 of the restatement is kind of mixing up the concept of this option with an acceptance. She's arguing that this option has the exact same effect as an acceptance, that the contract is already formed and then it just becomes a performance or breach issue after that. But that's not how that rule works. What Restatement 45 says, and the Rahoff agency's cases say, is that if you have an offer for unilateral contract and the offeree begins performance, they have an option to complete performance according to the terms of the offer. That's in the second paragraph of Restatement Section 45.
So you can't withdraw the offer while they're in the process?
You can't withdraw the offer, and Mr. Vignes did not withdraw the offer while the time period was still open. It had a deadline to do a certain thing. It was not done within that time. The offer, by its own terms, expired on the deadline. And this court, in fact, wrote in 1984, Sullivan versus Economic Research Properties, that when an offer is made for a time limited by the offer itself, no acceptance afterwards can make it binding. There's also a statement of a section of the restatement, Section 41, to the same point. Basically, when the time is out, the offer expires, and there's no contract. And that Rahoff agency's case is instructive. That was a case where there was an offer made to somebody that said, if you leave Miami, return to Atlanta, because he'd worked there before, we'll give you a job as a foreman once you get to Atlanta. So he did that. The question was, well, where did the contract come into existence? And they held an option started once he left Miami, but the contract was formed when he got to Atlanta. Well, our position is Ms. Rodgers didn't get to Atlanta. Suppose we add a fact to the Rahoff case.
She's in Waycross or somewhere, huh?
That's right. Although in Rahoff, the offer didn't have a deadline, so let's put a deadline on it. 30 days. If you leave Miami and you get to Atlanta in 30 days, you'll have a job as a foreman. Well, the claimant left Miami and saw what a nice city Savannah is, spent some time there, and was kicking back on the beach, and then the 30 days ran, he gets to Atlanta 45 days after the offer. He doesn't have a job. And that's our position here. The time ran out. The offer was not performed within that time, so there's no
In the Hansen
exception.
versus Maxfield case, it seems to me like it's unclear. The case is a little cloudy as to whether it was a offer for a unilateral or bilateral contract, but they seem to say that it was a bilateral contract. In other words, there was acceptance language in the acceptance letter. We accept your offer and we'll comply with the terms. And is there anything else that distinguishes that case?
Your Honor, that's exactly what they held. They held that was not a unilateral contract. They wrote that. I argued it was a unilateral contract, and they said, no, we disagree.
That was your case?
Yes, Your Honor.
Oh, okay.
So I was wrong, according to the First District. A couple of critical differences between that case and this case. One is the structure of the offer. Now, when Ms. Flowers talks about the similarity of the two offers, she's focusing on the terms. But I'm talking about how it's put forward as to how to accept it. In this case, there's an if-then statement. If I get this disclosure revealing no other coverage within 15 days and the checks, then this claim will be settled. The offer in Hansen versus Maxfield wasn't written that way. It started out with, my clients are ready to accept policy limits. Then later down, the release needs to be drafted a certain way. And then later down, and I want some more insurance disclosures. And then there was language, didn't make it to the opinion, so technically it doesn't count, but it's true. There was language implying, putting forth a 30-day offer or time limit, but it wasn't phrased the same way. So that looked more like, what the First District ended up holding was that, in that case, State Farm accepted the offer by writing back and saying, State Farm hereby accepts the offer you made on behalf of your clients. And that was all they decided. They didn't decide anything about whether it was actually performed. Well, in this case, the offer is written differently. Ms. Flowers conceded that it's an offer for unilateral contract. Another interesting point is that Mr. Romano's response to the offer didn't have that language. I hereby accept your offer. It doesn't have the word accept or agree anywhere in there.
Would that have made any difference?
Well, the point is simply that he only attempted to accept by performance. Didn't even attempt to accept by a promise. So it doesn't even it's not really an issue whether it's a unilateral or bilateral contract because he only tried to accept by performance and he didn't do it. And then when you get to the release issue, that completely makes it indifferent whether it was by performance or a promise or whether it was a bilateral or unilateral contract, because under the trend of the case law, the response by sending this release with a hold harmless and indemnity agreement in it was a counteroffer. When there's a counteroffer, the purported acceptance simply doesn't match the terms of the offer, and that acts as a rejection.
Because of the indemnity language in the releases?
Yes, because of the indemnity language. That it imposes additional obligations beyond merely releasing the defendant.
The case law talks about the fact that a standard release doesn't change the terms and isn't a counteroffer. And I guess my question is, it would seem like if the plaintiff offeror said that we're going to take care of all the liens, that the indemnity language would be standard in that kind of agreement. I mean, I would think that would be the normal course of things, that the other side wouldn't just say, oh, okay, that's fine, and then open themselves up to liability if you don't do what you said you were going to do. So why wouldn't that be just standard language for this kind of deal where part of your offer was, we're responsible to satisfy all the liens?
Well, I believe the correct way to implement that agreement would be that if the claimant did not discharge the liens and the defendant suffered some consequence as a result, that they would sue the plaintiff for breach of their agreement. The problem with this indemnity and hold harmless language is that it requires the plaintiff or the claimant to go beyond that.
And I guess there was no evidence taken as to whether that was standard practice, because, I mean, it would be I would think that would be a standard kind of thing to do if one side's going to take care of the liens for the other side for that side to agree to hold harmless. I mean, I would think that that's the way these are normally resolved in the profession.
Well, there wasn't, no evidence was taken on that. Mr. Romano put in a letter that they've used those kinds of releases before, but it's, I mean, to the extent that's supposed to establish a fact, it's hearsay. But also, the direction of authority now is that is not a standard term. That's what was held in Peraza v. Robles by the 3rd District and Grant v. Lyons by the 4th District. And then there are some earlier cases that were decided before all these negotiations, Chevrolet versus Geiser and Nichols v. Hartford, that stand for the proposition that if the plaintiff gets one of these releases, immediately sends it back and objects and says, I'm not agreeing to this, then there's no meeting of the minds over the release and therefore no settlement.
Before we turn to the set-off issue, let me ask you to address the argument that that term of the term of the offer requiring the disclosure was met before the offer was ever sent.
Yes, it wasn't.
Oh, well, let's move on then.
There you go.
Section 627.4137, it requires a statement from the insurer that discloses the names and coverages of all known insurers. Now, if there isn't a response to that says, I have no other coverage besides this policy, then the claimant never knows whether there are any other coverages, and the purpose of the statute isn't fulfilled. And that's why in Schlosser v. Perez, v. Perez, the 2nd District, pointed out that the claimant was never provided with a statement of other insurers or coverages or disclaiming any other insurers or coverages. Because you have to look at the claimant's perspective. What is he asking for? He wants assurance, or they want assurance in this situation, that there is no other coverage. So if you simply send a policy affidavit from State Farm that says this is a policy number and limits of this policy, and that's all you get, you don't know whether there's any other coverage. And on that point, I want to point out that there was some language in the offer that I believe Ms. Flowers overlooked. On the first page, this page 1139 of the record, where Mr. Vignes writes that he represents Ariel Rausin and Marilyn Dondero, and they are both ready to settle as soon as I confirm the extent of insurance coverage available. She wrote in a reply brief that there was no such language, but that's where it is. It's on the first page of that letter. And then on the second page, where he's setting out the terms of the offer, he writes that he has to get this insurance disclosure confirming that there is no other coverage. So it's clear that he is looking for some assurance that there is nothing other than this one policy that had already been revealed to him. And in fact, there was another policy. It turns out it didn't provide coverage, but that's the kind of information that he was looking for within the 15 days.
On the set-off issue, in looking at page 53 and 54 of your brief, you say that there's an exception for the rule, the DiMario rule, that the subsequent tortfeasor is not a joint tortfeasor, and the exception is when the two accidents or torts cause the same or similar injuries, and it's difficult or impossible to apportion the injuries between the two tortfeasors. And I guess my question is, why? This looks like a case to me where the exception should apply, because it seems really clear that the damages sought in the lawsuit below were the same damages sought from General Motors.
Based on the information we have in the record, I agree. It looks like there was one indivisible injury. However, it wasn't litigated. The evidence wasn't developed.
I mean, that argument was made that it was the same injury.
It was a fallback argument. It was a fallback argument by...
But, I mean, if that's true, then the judge got it right. I mean, treating them as joint tortfeasors.
That's right, and that's also my fallback argument on appeal. But my main argument is that because it was agreed that DiMario applied, it was presumed that GM and Ms. Rodgers were responsible for different injuries and not joint tortfeasors.
So your position is if they wanted to claim the benefit of the exception, they had to argue that GM should be on the verdict form under the exception because they are joint tortfeasors where the injury is not divisible.
Well, not as a Fabre defendant, necessarily. As a
Right.
matter of fact, D'Angelo v. Fitzmaurice says that you don't necessarily have to put another defendant on the verdict form to get a set-off.
Okay.
But the issue of whether the injuries are divisible or indivisible, apportionable or not, that is sometimes submitted to the jury. But that is a different question
Right, okay.
than putting them
So
on the
your
verdict form as a
position is
fabric
that
offense.
that's an issue that would have to be submitted to the jury for them to argue that?
It could be, yes, but we never got that far because they conceded that DeMario applied.
And the concession still holds, that DeMario, both sides still agree that DeMario applies, that this is an enhanced injury kind of case.
As I understood Ms. Flowers' argument, yes, that everyone agrees that DeMario applies,
So
and
does
they are not joint tort fees.
Does DeMario apply to non-economic damages?
Well, yes, well, the holding of it is that the automobile manufacturer and the negligent driver are responsible for different damages, and they're not joint tortfeasors. So they're not jointly and severally liable, and that would go across the board, both economic and non-economic damages. So neither is responsible for the same pot of money as the other, assuming DeMario applies, and so no joint and several liability equals no set-off. And if it does...
So you think there should be no set-off?
Yes.
And that's the cross appeal.
That's the cross
Yeah, I
appeal.
understand.
That's the cross appeal, because
If
it
you want to
was...
reserve some time on that, you can, but just let me know.
No, I mean, it's a pretty simple argument.
Let me ask you this. Do you believe that 768.041.2 applies?
Well, I haven't parsed out the differences between the three set-off statutes, but Wells versus Tallahassee Memorial Regional, yeah, it's a long name.
Yeah.
They hold that with all three set-off statutes,
Right.
presuppose joint and several liability.
Right.
So no matter which hole they put the peg into, there still has to be joint and several liability for them to be entitled to any set-off whatsoever. And under the concession that DeMario applies, there is no joint and several liability, and so no grounds for a set-off. The availability of a set-off doesn't turn on whether 768.81 applies. What the effect of 768.81 applies is that if it does apply, it limits the set-off to economic damages if a set-off is available. But to get a set-off in the first place, there has to be some basis for joint and several liability. It can be a joint tortfeasor relationship. It can be vicarious liability, derivative liability, and there's this Nations Bank case which appears to say that it can be some kind of contractual agreement, but there has to be some basis for joint and several liability or else there's no set-off.
And I guess in this case, the judge said, I'm finding that you can't apportion the damages or injuries between the two, and so that DeMario exception applies? Is that how the trial judge got to
Well,
the...
I don't think, well, he adopted, was it Mitnick? I believe Keith Mitnick's alternative argument that,
Right.
you know, if you don't go with my no set-off argument, our alternative position is that if the injury is
Yes.
indivisible, they're joint tortfeasors, and in that situation, they only get a set-off for economic damage. Excuse me, Your Honor?
He used the ratio, in other words.
That's right.
Yeah.
A set-off for economic damages
Right,
only.
right.
And that's our position on
He
appeal,
followed
too.
the formula in Wells, I guess it was, wasn't
Excuse me?
he? He followed the formula in Wells, or whatever.
That's correct. That's correct. And that's our fallback position on appeal, but our main position is that there shouldn't have been any set-off at all because there is no basis for joint and several liability.
It's interesting.
And then there hasn't really been any discussion about the verdict. I noticed this morning that I made a couple minor errors in referring to a couple cases about the award for pain and suffering damages. Sub-aqueous services, there's an award of $1.3 million for future pain and suffering. I wrote $1.4 in my brief. And the Pierre Rard case, that was $6.7 million for all non-economic damages, not just future. I want to correct that because that's my first time in front of this court, so.
Well, yeah, we probably won't hold you in contempt for that. But.
Okay.
It's a close call, but, you know.
But, you know, either way, even with those corrections, those awards were much higher than the award in
Right.
this case, so. So unless the court has questions about any of these issues,
Okay.
okay, otherwise I stand on the arguments in my brief. Thank you.
And you do still have a couple minutes if you want to come back and rebuttal to the issue on cross appeal, so.
Okay, thank you.
May it please the Court. I just want to go back to the Plaintiff's Counsel's settlement offer letter, because it is not clear that they were asking for anything outside the statute. And when you look at the language of the letter, what they're saying here they wanted was some type of a disclaimer is not what they asked for, because even on page 1 where they say, I want to confirm the extent of insurance coverage available. The extent of insurance coverage available was confirmed. It was a State Farm 2550 policy that never changed from the letter that was in plaintiff's hand when he wrote this letter. That was confirmed with State Farm's insurance disclosures
I'm just struggling
and the
with,
deck page.
I'm struggling with that argument, given the language in the letter. If I can get this coverage disclosure revealing no other coverage, and then ask for the declaration sheet. I mean, that to me sounds very clear, like they're asking for that kind of disclosure along with the sentence on the first page.
And then going to that paragraph with you, that paragraph begins by saying, I would like to request for your client to comply with the disclosure requirements of 627.4137. So they've defined disclosure requirements as being those encompassed within the statute, and then the sentence that's giving you more trouble doesn't change anything in that regard.
But what about the case law that they cited saying that the statute implies that you have to give the statement of no other coverage?
I'm not familiar with what case that is. There are usually specific requirements in these settlement offers that ask for affidavits of non-collectability, that ask for things like that. I'm not familiar with any case that says you can read into this statute a request for anything beyond what the statute asks for. And that was done. So within the 15 days, there was attempted performance on every material element of this offer. So if there was some technical, issue about whether or not it was satisfactory performance, that would become an enforcement issue. There was a settlement agreement, a firm contract.
I mean, attempted performance isn't good enough. Isn't sufficient.
It's more than attempted.
I mean, that's what you just said. There was attempted performance within 15 days, but to form a unilateral contract, you have to have completed performance that's exact and within the time and all those things that you stated in your brief. I mean,
and I think we can, let's call it completed performance, but they technically say that some part of this completed performance was technically defective. That's what they're arguing. But nothing that came up later showed that any of this performance was technically defective. Nothing that came up later showed that the statute required anything other than what had been done in this case. Nothing about the release that they've argued shows that there was anything technically defective in this release. This release was the standard release that would accompany a situation where the plaintiffs have offered to take on liens and subrogated interests. The irony of all this is that if you look at the release that they gave to General Motors, indemnity, hold harmless, 3 full paragraphs of it, not just the 1 paragraph that you have here. So clearly when they wanted to settle a case, they were willing to give.
With that issue, what's troubling me there is it sure looks like a counteroffer unless there's evidence and a finding that this kind of release or the indemnity language is standard for this kind of offer that will take care of the liens. And I don't see that finding, and I don't see any evidence that would support that kind of finding.
Well, there is no finding, but we know from the case law and enforcement of release agreements that this is the type of provisions you put into a release if someone has agreed to take on in the liens and the subrogated interests. And so there's nothing really ultimately defective about any of the performance that was given as of that 15-day deadline. So there was no basis for the trial judge to hold that there was a failure of settlement in this case. And we'd ask that the course reverse on that as well as the other issues. And I want to point out that in regard...
You're already your time. I want to see if there are any questions.
No.
Okay, and since we didn't get to the cross-appeal issue, there's nothing to rebut there. We'll stand in recess. Thank you. Well-argued case.
Thank you.